Constitutional challenge to the administrative state case name, We the People v. Criminal Enterprise Administrative Law Court. Federal Court Jurisdiction Case Number. Case Number Introduction. This lawsuit challenges the constitutionality of the administrative state, a system of administrative agencies within the executive branch wielding quasi-legislative, quasi-judicial, and executive powers. This system flagrantly violates the Constitution's non-delegation doctrine, separation of powers doctrine, and fundamental checks and balances. Statement of facts. Congressional delegation of legislative power. Congress has abdicated its legislative power by delegating broad lawmaking authority to administrative agencies. These agencies promulgate rules and regulations having the force of law, circumnavigating the legislative process and accountability. References to legal precedents that expose the unconstitutional nature of the administrative state. For instance, analyze cases like A. L. A. Schechter Poultry Corp. v. United States 1935, where the Supreme Court struck down a part of the National Industrial Recovery Act, highlighting the delegation of excessive legislative power. Draw parallels to more recent cases, such as Gundy v. United States 2019, where the non-delegation doctrine was challenged, indicating a continuing issue. Additionally, explore Chevron U.S. A. Inc. v. Natural Resources Defense Council, Inc. 1984 to illustrate the deference given to administrative agencies, reinforcing the argument that they have been granted quasi-legislative powers, further violating the non-delegation doctrine. Executive power grab. The executive branch controls these agencies, wielding vast legislative and judicial powers beyond its constitutional mandate. This concentration of power undermines the separation of powers and allows the executive to operate unchecked. To fortify the argument against the executive power grab within administrative agencies, we leverage legal precedents that expose the overreach of the executive branch. Case in point, Morrison v. Olson 1988, where the Supreme Court upheld the Independent Counsel Act, illustrating the judiciary's reluctance to curb executive authority even when it encroaches on its powers. Reference Youngstown Sheet and Tube Co. v. Sawyer 1952, highlighting the court's rejection of executive overreach during the Korean War. This precedent underscores the importance of maintaining a strict separation of powers and preventing the executive branch from wielding legislative and judicial powers beyond its constitutional bounds. Integration of these legal precedents within the narrative, emphasizing how the concentration of power within administrative agencies allows the executive to operate unchecked, undermining the delicate balance of powers envisioned by the Constitution. This strategic use of precedent adds weight to the argument against the executive's unconstitutional expansion of authority. Erosion of judicial power. Administrative law judges (ALJs) are not Article III judges and lack judicial independence. They serve at the pleasure of the executive, rendering them susceptible to bias and compromising their ability to provide impartial adjudication. Exploitation of legal precedents to expose the erosion of judicial power through the lack of independence in administrative law judges (ALJs). Reference Lucia v. SEC 2018, where the Supreme Court questioned the constitutionality of the sex ALJs, highlighting concerns about their appointment and removal procedures. This case can be used to emphasize the vulnerability of ALJs to executive influence. Draw parallels with Freitag v. Commissioner 1991, where the court acknowledged the quasi-judicial nature of special trial judges in the IRS but also emphasized the importance of preserving judicial independence within the administrative process. This precedent reinforces the argument that ALJs, lacking Article III status, compromise the separation of powers by serving at the pleasure of the executive. Incorporation of these legal precedents adds strategy to build a case against the erosion of judicial power within administrative agencies. Emphasize how the absence of judicial independence in ALJs undermines the integrity of adjudication, making it susceptible to bias and executive interference. Furthermore, adding the highly acknowledged book Administrative Law 6th edition to evidence will further elaborate the great lengths the administrative branch will go to achieve its corruption. Deprivation of rights. The administrative state enables the executive to deprive citizens of their constitutional rights without due process. ALJ decisions lack the procedural safeguards of Article III courts, leading to unfair outcomes and undermining the rule of law. To underscore the deprivation of constitutional rights within the administrative state, we leverage legal precedents that expose its unconstitutional nature. Referencing cases like A. L. A. Schechter Poultry Corp. v. United States 1935, and Gundy v. United States 2019 will establish a historical context, emphasizing the ongoing challenge to the non-delegation doctrine and the excessive legislative power granted to administrative agencies. Additionally, integrate Chevron U.S. A. Inc. v. Natural Resources Defense Council, Inc. 1984 strategically to highlight how the deference given to administrative agencies contributes to a lack of procedural safeguards. Emphasize how this deference allows the executive to wield quasi-legislative powers without due process, resulting in unfair outcomes that undermine the rule of law. By weaving these legal precedents into the narrative, you can construct a powerful argument against the administrative state, showcasing its role in enabling executive deprivation of citizens' constitutional rights and emphasizing the need for procedural safeguards akin to those in Article III courts. Abuse of the wedge principle. The administrative state exploits the wedge principle by using agencies to create a layer of bureaucracy between Congress and the people. This shields the executive from accountability and hinders meaningful public participation. Collusion and failure to act. All three branches have failed to act effectively to check the growth of the administrative state. This inaction suggests tacit approval and undermines the system of checks and balances intended to safeguard individual liberties. To strengthen the argument regarding collusion and failure to act against the growth of the administrative state, draw upon legal precedents that highlight the concerning trend of inaction across all branches of government. Refer to Inns v. Chadha 1983, where the Supreme Court struck down the legislative veto, indicating a reluctance to check the growth of administrative power. This case can be used to illustrate how even the judiciary has failed to effectively intervene in restraining administrative overreach. We present an interesting perspective on the Supreme Court's decision in Inns v. Chadha 1983. While it's true that the court struck down the one-house legislative veto in that case, there are different interpretations of its implications for administrative power. Here are some points to consider. Arguments against our claim. Focus on separation of powers. The primary concern in Chadha was upholding the Constitution's designated processes for lawmaking. The court argued that allowing one house of Congress to unilaterally overturn executive decisions violated the principles of bicameralism and the presentment clause. This doesn't necessarily reflect a reluctance to restrain administrative power, but rather a commitment to ensuring proper checks and balances within the legislative branch. Other limitations on administrative power. Chadha isn't the only case where the court has intervened in administrative overreach. There are numerous instances where it has invoked doctrines like Chevron deference, agency rulemaking procedures, and judicial review to keep administrative actions within constitutional bounds. Increased judicial scrutiny. Since Chadha, there has been a trend towards stricter judicial scrutiny of agency actions, particularly those considered major rules with significant economic or political ramifications. This suggests a continued effort by the judiciary to hold the administrative state accountable. Points to consider for our argument. Limited scope of Chadha. The decision specifically targeted the one-house legislative veto, and its impact on other forms of congressional oversight of agencies is debatable. Some argue that Congress still retains significant tools to influence and inform agency actions, even without the veto. Challenges in defining and measuring administrative overreach. The concept of administrative overreach itself can be subjective and contested. What one person sees as an overstep of agency authority, another might view as necessary regulation or efficient policy implementation. Defining and measuring this phenomenon can be complex, making it difficult to assess the effectiveness of judicial intervention. Potential trade-offs. Restricting administrative power can have unintended consequences. While it might prevent agencies from exceeding their authority, it can also hinder their ability to respond quickly and effectively to complex issues. Striking a balance between accountability and flexibility can be challenging.